Assalamualaikum and a good day to everyone. My name is Ahmad Nabi bin Ahmad Faisal. Today, my colleagues and I will be discussing on the case of Mr. Andrew and the clients will be advising. But first, let me introduce you to the rest of the team. Our team consists of Serena Suresh, Isha Prikaur anak perempuan Gurpinder Singh, Emmanuel Jamba anak Enjang, and yours truly. Before we get started with the discussion, let me brief you on the case. Andrew and Rose had discussed on 1st January 2021 whether Andrew will sell Rose his house. Rose made a phone call to Andrew on the 2nd January and agreed that she would pay RM 200,000 for the house. However, she would like to pay James 3 installments for the payment. Andrew just kept silent on Rose's request for an installment payment for 200,000 ringgit. Andrew informed Rose that he will call her again the next day. Andrew has now received a better offer and says that he intends not to proceed with the sale of his house. Andrew wrote a series of letters to William, a cousin who lives in Penang, inviting William to join his business in Melaka. Andrew promised William that he will receive a 10% profit annually as long as the company is making a profit. William sends a letter of resignation to his employer and then moves to Melaka. In 2020, because of the movement control order, the company has not made any profit. Andrew then informs William that he will need to shut down the business as there is no profit. William now wants to claim the 10% annual profit. Andrew and Selena are to be married on the 31st November 2022. Andrew had promised Selena that after their wedding, he will give her an allowance of 1,000 ringgit every month. Andrew convinced Selena that he will allow her to work after the wedding. After the wedding, Selena received a job offer as a legal advisor at Celtom Sdn Bhd. Andrew disagrees and does not allow Selena to work. At the same time, Andrew does not fulfill his promise to give her an allowance every month. Shortly after that, Andrew and Selena lived separately. Andrew did not usually consume an alcoholic drink, but he went through a rough divorce. During this period, he went out for dinner with some friends, and although he only had 2 drinks, he woke up the next day with no recollection of what happened the night before. Andrew received a phone call from his friend Alex, who told Andrew that he had agreed to buy Alex's watch. Andrew could not recollect the events of that night. Alex now wants Andrew to make payment for the watch. Advised Rose, William, Selena, and Alex on whether they could take action against Andrew. Now with that out of the way, let us begin our discussion. I will now give the floor to Serena to provide her counsel to Rose.
Good morning. My name is Serena and I will be explaining about issue 1 between Andrew and Rose. Andrew and Rose had discussed on the 1st of January if Andrew would sell his house to Rose. On the 2nd of January, Rose had called Andrew and agreed to pay the sum of 200,000 ringgit and to buy Andrew's house. But she had her own requirements. She wanted to pay Andrew in 3 separate installments instead of paying one lump sum. Andrew just kept silent on these requirements and told Rose that he would call her back again the next day. Andrew then received a better offer and decided to go with that offer instead of this with Rose. The issue in this case was to determine if Andrew's silence towards Rose's requirements amounted to an acceptance. In Section 2B of the Contracts Act 1950, an acceptance is defined as when the person to whom the proposal is made to signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. For an acceptance to be accepted and valid, there are certain requirements in accordance with Section 7A and Section 7B of the 1950 Contracts Act. Section 7A states that an acceptance must be absolute and unqualified. Section 7B states that an acceptance must be expressed in some usual and reasonable manner, which unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes a manner in which it is to be accepted, and the acceptance is not made in that manner, the proposer may, within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in the prescribed manner, and not otherwise. But If he fails to do so, he accepts the acceptance. There are a few modes of communicating an acceptance. The statutes on the methods of acceptance are in accordance to Section 3 of the Contracts Act 1950. It provides that communication of a proposal or an acceptance or even revocation can be made in action or in a way of omission, as long as there is an intention of communicating or there is an effect of communicating it. In Section 9 of the 1950 Contracts Act, it is provided that an acceptance can be either made expressly, which means in words, or impliedly, which means in action. In Section 4, subsection 2 of the Contracts Act 1950, it is stipulated that an acceptance is complete when a. towards the proposer when it is put in a course of transmission to him, so to be out of the power of the acceptor, or b. to the acceptor when it comes to the knowledge of the proposer. In contract law, silence does not usually amount to an acceptance unless the offerer has stipulated that his silence amounts to an acceptance. Let's look at Fraser and Everett's 1889. In this case, it is about a contract for shares. The plaintiff did not reply to the offer letter and the defendant took it as the plaintiff had accepted the offer letter. The court held that there is no rule of law saying that silence amounts to consent to the offer. Hence, the general rule is that silence does not amount to acceptance. Let's also look at the case Re Select Move Limited in 1995. In this case, it is highlighted that silence may amount to an acceptance if there are other facts such as the conduct of the offeree to indicate an acceptance. In this case, it had been held that the receipt and reading of a periodical after the expiry of a subscription amounted to an acceptance. This is because when the offerer indicates that silence amounts to acceptance and vice versa, speaking amounts to rejection of the offer. Hence, the said judge viewed that there would be an exceptional circumstance that at certain circumstances, the offer can be accepted by silence. In the issue between Andrew and Rose, after Rose had agreed that she would pay 200,000 ringgit for Andrew's house, but in 3 installments, Andrew had kept silent and did not stipulate that any silence meant an acceptance. There was no proper terms or conditions for this case. Andrew was not happy and he did not respond to Rose's requirement. He stated that he will call her again the next day, but there is no proper indication that he actually did. This shows that Andrew is deciding to stay silent instead of agreeing to Rose's requirements. We can conclude that there is no valid acceptance of the requirements made by Rose as Andrew did not respond to it. And without response to an offer, there is no valid and binding contract as silence does not amount to acceptance unless it was specifically stated by Andrew. That is all from me. Thank you very much.
So the next case is Andrew wrote a series of letters to William, a cousin who lives in Penang, inviting William to join his business in Melaka. Andrew promised William that he will receive 10% of profit annually as long as the company is making profit. William sent a letter of resignation to his employer and he moves to Melaka. In 2020, because of Movement Control Order (MCO), the company have not made any profit. Andrew informed William that he needs to shut down his business as there is no profit. Now William wants to claim the annual 10% profit. The issue here whether William able to claim the 10% annually profit or not. According to Section 2 of Contract Act 1952, Section 2 subsection D Contract Act of 1950, when at the desire of the promisor, the promise or any other person have done or abstract from doing or does or abstain from doing or promise to do or to abstain from doing something such as act or absence for promise is called consideration for promise. Other than that, according to Section 2 subsection E of Contract Act 1950, every promise and every set of promise forming the consideration for each other is an agreement. Other than that, agreement without consideration is void unless, according to section 26, an agreement without consideration is void unless it is a promise to compensate for something has been done. It is a promise to compensate wholly or in part to a person who has already voluntarily done something for the promisor or something which has the promisor legally compelled to do so. In the case of Carlick versus Carbolic Small Ball Company, Mrs. Carlick purchased some small balls and used them according to the direction and court flew and the sought to claim the stated 100 reward. One of the issue was raised in this case was that there was no consideration. However, it was not true as there was executed consideration where the defendant advised to advertisement promised of a reward to person who used their small ball in a certain manner. In another case, Wong Hong Leong David versus Nur Azman Adnan. This case can be used for both execution and executory consideration because of the reference to both. In the case, the appellant owed 3 lots of agricultural land in Kajang. The appellant agreed to pay the respondent a fee for his assistant to obtain a letter of support from the Menteri Besar Selangor for conversion and subdivision of the land in order to develop land into a housing estate. The application for conversion and subdivision were approved, but the appellant refused to pay to the respondent on the ground that there was no consideration was allied. But the court held that there was a promise in exchange for promise and it was a good consideration that been made in the case. Another case that can relate to this issue is Price versus Aston 1983. Aston made a contract with X that in return for X doing work for him, Aston would pay him. X did the work, but Aston did not pay. So Price sued X. It was held that Price's claim was failed because there was no provided consideration. In this case, Andrew promised William that he will receive 10% profit annually as long as the company is making a profit. There was stated that as long as the company makes the profit. Due to the MCU, there wasn't any profit. There was no any consideration because that as long as there is profit, then he will receive the 10% annual profit as well. In conclusion, in this case, William could not claim 10% annually profit as the agreement is void because of the consideration is not accurate. Thank you.
Hi, my name is Emmanuel and I'm going to discuss about the issue between Andrew and Selina. So, the facts of the case between Andrew and Selina is that they are to be married on 31st of November 2022. Andrew had promised Selina that he will give her an allowance of 1,000 ringgit per month. Andrew convinces Selina that he will allow her to work after their wedding. After the wedding, Selina had received a job offer from Selterms in Berhad. Andrew disagrees and does not allow Selina to work, and at the same time, Andrew does not fulfill his promise to pay her the allowance. So after that, Andrew and Selina live separately. So the issue is whether promise made by Andrew is legally binding. In the case of Balfour and Balfour, the husband brought his wife to England from Sri Lanka, leaving his wife due to medical reasons. The husband promised to pay the wife for £30 per month until he returned. The wife had sued the husband because he failed to pay the amount of £30 per month. The court held that the wife's action failed because there is no intention to create a legally binding agreement between them. So Lord Atkin, in his judgment, stated that the parties in this inception of the arrangement never intended that they should be sued upon. So applying the principles of the case mentioned just now, Andrew had promised to pay Selina for 1,000 ringgit every month. Andrew then disagrees with Selina to go to work after she received a job offer at Selterms in Berhad, even though Andrew had convinced Selina to work after their wedding. Both Andrew and Selina never intended that they should be sued upon. So in conclusion, Selina could not sue Andrew. So that is from me. Thank you.
Hello again. We're finally at the last situation. Just to recap, the fourth situation is between Andrew and Alex. We know that Andrew went out for dinner with some of his friends, and although he only had 2 drinks, He woke up the next day with no recollection of what happened the night before. Andrew received a phone call from his friend Alex, who told Andrew that he had agreed to buy Alex's watch. Alex now wants Andrew to pay for the watch. The situation here is to determine whether there is a valid contract between Alex and Andrew. We will also determine whether Andrew was legally capable at the moment of entering into a contract with Alex. In order to determine legal capacity, we must first understand what is capacity. Section 30 of the Contracts Act 1950 provides that capacity is agreements, the meaning of which is not certain or capable of being made certain is void. In the case of Karupanchetty v. Suatian, 1916, the case concerns with the sale of a car. It certifies that there must be a certainty as to the model, price, and conditions of the car that is being sold. Otherwise, such an agreement is void on the grounds of being uncertain. So, who is considered a competent person to enter into a contract? Section 11 of the Contracts Act 1950 states that a competent person is someone who is of age of majority according to the law, who is of sound mind, and is not disqualified from contracting by any law to which he is subjected to. We know that in the situation between Andrew and Alex, both parties had some drinks the day the agreement took place. Andrew was unable to recollect the events of the night before. Drunkenness can affect the validity of an agreement. Section 12 of the Contracts Act 1950 states that a person of a sound mind will have an influence over the validity of an agreement. To relate with our situation, illustration B of Section 12, Clause 3 provides that a sane man who is delirious from fever or who is so drunk that he cannot understand the terms of a contract or form a rational judgment as to its effect on his interests cannot contract while such delirium or drunkenness lasts. The case of Gore and Gibson, 1845, also confirms that a person who is intoxicated by alcohol or drugs is held to have an unsound mind. However, in the case of Matthews and Baxter, 1873, if a drunken party, upon coming to his senses, ratifies the contract, he is bound by it. In simple terms, if he is able to confirm the exchange and agree to the terms, the contract is valid. It is important to note that a contract is only valid if acceptance is done with free consent. To be more specific, Section 14 of the Contracts Act 1950 states that consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. Undue influence would be the most relevant to our case, as Section 16, Clause 1 states that a contract is said to be induced by undue influence where the relations subsisting between the parties are such that one of the parties is in the position to dominate the will of the other and uses that position to obtain an unfair advantage over the other. Alex would need to clarify whether at the time of the agreement was being made, Andrew was sober and was capable of engaging into a contract. If he was not, then Alex may have unknowingly or knowingly took advantage of Andrew in that situation. So, based on this situation, we can determine that Andrew became intoxicated after having only 2 drinks with Alex. Andrew woke up the next day with no recollection of what happened in the night before. Although Alex called Andrew to talk to him about the agreement, Andrew was not able to recollect the events that transpired the night before. Therefore, it can be determined that Andrew was not in the state that constitutes him as of sound mind at the time he entered into a contract with Alex. Upon coming to his senses, Andrew was not able to certify whether he had agreed to enter into a contract with Alex. This shows an unfair advantage Alex had over Andrew. In conclusion, there was no valid contract between Alex and Andrew. The contract was deemed void because Andrew was of unsound mind and the agreement was made under undue influence.